Daily podcast that shines a light on the American justice system and its role in empowering the powerful to take from you. The justice system is the only branch of your government where an individual, rather than the collective, can make the system act for you. It puts power in the individual's hands, but it's broken and being used against you at a time when you need it most.
And we are live on Who Wrote That Up for You. Today is Thursday, November 17th, 2022. I'm Sonia Ebron, co-founder at Courtroom 5.
And I'm Deborah Sloan, the other co-founder at Courtroom 5.
Delightful show lined up for you today. In a few moments, we will speak with Olivia Miller. She's a junior partner at the Barr law firm in Central Florida, and she has some experience with pro se litigants in the courts and has some resources to share and some advice for them. Before we get there, though, Deborah, what is on your mind today? What's your issue of the day?
My issue of today is hospital payment plans that, unfortunately, one of the biggest culprits of this, of companies that, hospitals that are working with companies to collect patient money when a patient is unable to pay all the money up front or may not have insurance. They make this deal with a credit company to basically collect the money with big interest rates. And used to be that people would pay the hospital and there would be no interest rates. There would be no interest, but now they're charging these great big interest rates. And one of the worst culprits is a North Carolina-based company called Atrium Health, and they are. What happens is a person is unable to pay their bills, and they basically talk up this credit company, and the company gives them a good loan, and what they say is a good loan, and customer sometimes they're sick, they're not sure what's going on. One person was going through cancer treatments, and she came out, and there are all these bills from this company that she didn't really know about. The company that she didn't even basically know, and so that's my biggest issue is that now they're now it's like making a bunch of money off of poor people. The more money you have, the more ability you have to pay up front, the less interest rate you have. So they're charging the poor people more money to basically to get well. And if things don't work out and people aren't able to pay, they take them through the courts, and it's just really, I think, a sad situation. So that's my issue.
I appreciate you bringing that up. We talk frequently here about ways that folks are making money off poor folks these days, and that's not the way I think our economy is designed to work, or maybe it is. I don't know. I'm trying to not be cynical
Mm.
on that, but the Pew Research Center did a major study on debt collection in the courts. I believe it was very early this year, maybe late last year. And this is, I think, one of the uh, factors that are driving so many debt collection cases is when people are sick or in desperate circumstances, and then you offer them credit at just ridiculous interest rates. It's not not the best way, but we see the courts having to handle all of these issues here, and that is really unfortunate. So, sorry to hear about that. Well, Who Wrote That Up for You is sponsored by Courtroom 5. At Courtroom 5, we believe the courts belong to the people, in particular to the people who use them. And we the people are coming to claim our courts. So if you are in court without a lawyer, or you need to sue someone and can't find a lawyer to represent you, get yourself over to courtroom5.com. Try a limited version of our services for free, and we hope to provide some relief for you there. At this time, it's my pleasure to welcome onto the show Olivia Miller, the junior partner at the Chad Barr law firm in Central Florida. Olivia, thank you for joining us on Who Wrote That Up for You. And I think we may have audio issues there. Olivia,
Wait,
make sure that you
is your
turn
mic
your
on?
audio. You know, we love to pick on lawyers and tech issues on this show. It's not unusual. Olivia, I think you've turned your camera around so that we are seeing the other part of your room there. And so we'll give Olivia a moment uh, to um, to check her
Audio.
situation there. Yep,
Hmm.
absolutely. And we'll be back with her in just a moment. How's that, Olivia? Is that a little better? Not quite. So there's a speaker button somewhere on your phone there, on your computer there. Might be helpful for you.
Can you hear me now?
Yes, we can.
Yes.
Oh,
I
that's
hope.
wonderful. Nope, you're
Oh,
perfect.
excellent. I'm
You
so
are
sorry
perfect.
about that. You know,
Not a
we've been doing
worry.
this for 2 years, and, attorneys complain about other attorneys not being able to use technology. So it's understandable. Everyone complains about attorneys, really.
We have a good time picking on your profession, and we often joke that lawyers
That's okay.
are second only to physicians as being sort of tech phobic or behind the times. And we've actually had lawyers argue with us on this show that no, lawyers are number one. Lawyers are number one there. So I understand. I'm
No.
glad
We're
you could
terrible.
join us.
Honestly, the pandemic is thank you so much. The pandemic is really the only reason why courts have gotten with the times. So
That's
in that way, we've been a little bit lucky because we got to move forward quickly.
That's right. That's right. Well, you know, pro se litigants have benefited from some of those changes as well. Not having to take a whole day off of work to come to court when you can just get on Zoom now at the time of your hearing. So it's much easier for all of us. Well, thank you again for joining us, Olivia. Give us your background. What got you into the practice of law?
So, well, I hate to say this, but it was my dad. He told me for years that I would be a good attorney, and I said, absolutely not. I'm never going to be an attorney. I'm going to be an art historian. I worked at an art museum. And then I realized in about 2008 that it was time for me to go to law school. So I said, I will never, ever be a criminal defense attorney. I was a criminal defense attorney. That's how I started. I was a public defender. And then I moved to insurance defense, and now I do personal injury and insurance litigation at our firm.
Fantastic. That is great. And so in your practice there in Central Florida, I imagine you have the opportunity to witness the experience of pro se litigants. Can you share a bit about what you've seen?
Absolutely. So actually, my experience with pro se litigants starts at the very beginning of my career when I was a public defender in Orange County. As a public defender, you are tasked with representing anybody who needs an attorney, and that includes pro se litigants. So I've actually gone to trial with a pro se litigant. I was the sort of backup attorney if that person had questions, and I was able to help that person get through his trial. And represent himself. It was just a misdemeanor trial, so it was not, there weren't incredibly high stakes like there can be in criminal court. But so that's where it started, was with helping those types of people who needed representation, who were representing themselves in a criminal setting. Now, I've seen a lot of pro se litigants. I do a lot of work in Florida's small claims court because of our insurance litigation. And there are a lot of people who represent themselves in small claims court. So I've had the benefit of seeing a lot of those kind of people, especially during COVID. Now we're able to sit in, so to speak, on all kinds of cases because we'll be waiting for our turn in a hearing in a Zoom meeting. And we'll see pro se litigants acting on their own behalf with the judge. And we get to see how those hearings go and how those trials go.
Fantastic. Well, how do they fare in small claims cases there?
So in small claims court in Florida, pro se litigants actually get to interact with judges and the opposing party in ways that normally people don't get to. So judges, I think people will find, are incredibly helpful people. The reason they're judges is because they want to help people. And the pro se litigants will be able to ask questions. Obviously judges can't give legal advice, but judges are absolutely able to say, here are resources that are available to you, or, tell me about your situation. There's a lot of leeway given to people who are representing themselves as far as procedure and form. And, judges really will take into consideration that a person does not have a formal legal background when they are.
Uh-oh. Looks like we have lost Olivia there for a moment. Oh, welcome back. Sorry, I think you disappeared for just a moment there,
Thank you.
Olivia.
Sorry.
It's all great. We caught the last bit of that. So absolutely, I think in small claims court we've seen similar things. Judges will tend to bend over backwards. Judge Judy has been fabulous in sort of maybe educating the entire judiciary about how to handle folks in small claims court. Do you see in small claims pro se litigants opposed by represented parties, or is it usually two pro se litigants against each other?
It's almost always, in small claims court in Florida that I have seen, it's almost always a pro se litigant against an attorney. And that's really difficult for the pro se litigant because the attorney very well could know the judge. The attorney knows the procedures. The attorney knows the rules of, civil procedure and criminal procedure. So it's really difficult. It's also difficult, to be fair to attorneys out there. It's hard for us to litigate against pro se litigants because we don't want to do anything that would be unfair to that person. And so it's just inherently unfair when there's an attorney who is arguing against someone who's not represented.
Absolutely. Absolutely. In small claims court, you wouldn't think there would be a whole lot of procedure to understand, civil procedure or anything like that. But this is Florida. Is that your experience? Are there multiple filings and court appearances and all of that you might see in some of the courts upstairs, if you will?
Definitely in the lower courts, a lot of the time the procedure still comes into play. You have to be able to get into court. So the procedure, so filing a lawsuit, serving a lawsuit, defending a lawsuit, filing pleadings, all of those things are very difficult if you're a pro se, anybody acting on their own behalf. Even just filing an answer, if you're sued on your own behalf, is difficult because you have to have a login to be able to do that. In Florida, we're lucky that everything is done through e-filing, but other places, the Middle District of Florida, for instance, or federal court, you have to be able to have a login to be able to file pleadings. So it's very difficult, and it is definitely made easier with the clerks and judicial assistants and judges who are all willing to help people who are representing themselves with how to get those things done, how to file those things, how to represent themselves. They're really great about helping.
That's fantastic. That is fantastic. And as you mentioned, there are clerks, there are judicial assistants, and those are folks that work with your judge. And they provide tremendous information, I guess. Can they give legal advice?
They cannot give legal advice. The only people who can give legal advice are attorneys, and really the only legal advice you should take is from an attorney you've hired. But the great thing is that the judicial assistants and clerks and deputies who are located in courtrooms, and really just anyone who's in the justice system, has experience with how exactly you go about doing things. They are absolutely willing to help show you, the right place to go, the right website to go to tell you here's what you need to do. Even if you were just in a hallway outside of a courtroom and strike up a conversation with someone, in my experience, people are absolutely willing to give advice, and not like about your particular case, but maybe about here's the step that you need to follow, or here's this judge's judicial assistant, contact this person, here's the website to go to. So those kind of resources, and just going into a courthouse and being around, and that's a lot easier now than it was in the past couple of years. You can absolutely just go in and start talking to people. The same goes with calling. You know, you can always call a judicial assistant. You can always call the clerk's office. You may have to wait on the phone for a long time because there's a lot of staffing issues now, but people are always willing to help, especially with people who are representing themselves, because those people who are involved in the court system know how difficult it is.
Yeah, absolutely. The courts themselves, the court's website, for instance, might also have some resources that are useful. And Florida does a good job in all 59 counties. Do you have there? It's just trying to educate the public about court procedures. But what have you found there in Central Florida?
You're absolutely right. The courts in Florida are fantastic with having policies and procedures and examples of things on their websites. I think a great piece of advice is for a pro se litigant to go into websites. So, for instance, the Ninth Judicial Circuit in Florida, that's Orange and Osceola County here. They have a great website where there are lots of different resources about representing yourself. Then also, I would recommend going into the for attorneys sections of any court website. Those sections will have different things that you can just click through. It's not, you don't have to have a login to access that. You don't have to be a member of the bar. That's all open to the public in Florida. And so those resources can help you as well, even if it's just understanding that in Florida we have deputies instead of bailiffs. That's a distinction that you may need to know to get your point across or to ask the right questions. So those kind of resources for attorneys and for the general public are great resources for anybody to go to. Federal courts also have those resources. They may be, it may be difficult to understand what you're looking at, but you can always Google information. You can always just look up on the internet any kind of terminology that you don't understand, and pretty much everything is available to you now. So it's great to just be able to look through websites. It may take you a lot longer than it would take me because I already know that information. But if you're representing yourself, absolutely find out as much information as you can and utilize those resources that are available.
That's fantastic. Thank you so much for sharing that. Olivia, let me ask one last question then. So you see in small claims court, I think it's called county court there in Florida, you see pro se litigants opposed by represented parties, lawyers like yourself. Even with all the resources available and the clerks and judicial assistants, which I know personally are just fantastic, doing everything they can to help. What's the win-loss ratio? What's the chance of a pro se litigant really having the ability to be heard or to win a case in small claims when there's a lawyer on the other side?
It's very difficult. There are just things that attorneys know to file. There are things that attorneys know to do that the general public you will never know how to do that because we've gone to law school and we've done this job. It's just like, I have no idea how to blow dry my hair correctly the way my hairdresser does. So it's exactly the same. I can't do plumbing. But it's really difficult to win. Winning is kind of it's how you see that word. If you're representing yourself, let's say for instance in a credit card case, you have been unable to pay your credit card and you're sued by the credit card company and you represent yourself. A win may be connecting with the other attorney and establishing some sort of payment plan. That could be a win for you. A win could be, anything like that where it's something that is in your best interest or best for you, but it's not necessarily, your case isn't thrown out. That's a kind of scenario that's really unlikely to happen when you're going against another attorney. But definitely there are ways you can represent yourself and help yourself and do what's best for you in your own life.
Excellent. I appreciate your candor there and that wonderful advice. Olivia, I'm going to share your law firm's website on the screen for our viewers. That's the Chad Barr, Barr law firm in Central Florida. Thank you so much for joining us. Where else can people find you online?
Thank you so much. You can find us at all Chad Barr Law, at Chad Barr Law. We're all over all the social medias and our website, which you kindly put up on the screen.
We really appreciate you for joining us. I know you all have had a hurricane there recently, and so things are still a bit shaky. I hope everyone is well and wish you the best of luck and continued success in your career. Thank you so
Thank
much,
you,
Olivia.
Olivia.
Thank you. You too as well.
All right, fantastic. Always appreciate a lawyer who can be candid about the experience of pro se litigants in the court, and really appreciate her for sharing those resources and that great advice.
Absolutely.
Deborah, let's find out who won yesterday's quiz and what you have teed up for us tomorrow.
Okay, we do have a winner. The question was, which principle of law says that an amendment to a pleading will be treated as though it were filed at the time the original pleading was filed? And the choices were statute of limitations, discovery rule, stare decisis, and relation back. And the answer is, of course, number 4, relation back. For example, if you want to amend your complaint, and it's long after the statute of limitations uh, for the actual filing, it's okay because it relates back to the actual date of the filing. Any amendment would relate back to the actual date of the filing. So the winner was Kira J.
Oh, congratulations to Kira there. I am sure Kira is not the Courtroom 5 member who filed her complaint the day before, I believe, the statute of limitations would have expired so that she could file an amended complaint a little bit later that was a little bit more prepared. Sure, that's not the Kira who did that, but congratulations to Kira.
And today's quiz, which of the following is a standard of review on appeal? Probable cause, clearly erroneous, preponderance of evidence, or reasonable suspicion? If you want to participate in today's quiz, send your responses to quiz@courtroom5.com.
Fantastic. Looking forward to the answers there. And now we have a surprise and special guest. Brian Vukadinovich joined us at the beginning of our podcast on day one and just really set us up for a great season 1 here. And so we wanted to bring him back here on day 49, episode 49 of the podcast. Brian, I should let you know, and we've announced to our audience that Deborah and I are going to take a brief break, about a 3-week break after tomorrow, after episode 50. And so we wanted to just bring you back and just recap the season with you and to chat briefly. We've had the opportunity to speak with a number of lawyers, with a number of pro se litigants, with a number of people working on access to justice issues throughout the legal profession and in the courts. We've learned a lot this season, but I wanted to just circle back with you because I know you also study these issues from a different perspective, a much more on the ground perspective, if you will, and just get your sense, Brian, of what is happening today in the courts and why is it so hard for people to access our justice system?
Well, first of all, hello, Sonia. Hello, Deborah. How are you doing?
Hi,
I've been
Brian.
following your interviews. You've been doing a great job. So keep up the good work with the show. Keep it going. And congratulations to Kira for answering that really good question by Deborah as well. And I was able to catch the latter part of the interview you were doing with Olivia. And basically, in a nutshell, to answer the question you posed to me here, now, I know your interview with Olivia was related to small claims cases, and then your question at the end was the success rate that pro ses might have in small claims court against lawyers, and she pretty much said it all with 2 words. She said very difficult. That was her answer. So my way of thinking is, well, doesn't that defeat the whole purpose of small claims court then? It's not supposed to matter if there's an attorney involved in the case or not. So, I mean, she gave a very direct, honest answer. It's very difficult, and it's not supposed to be. So, and that's how it is, in the larger picture with all of the courts, whether it's small claims court, state court, federal court. It's the same. It's the same thing. Bottom line, it comes down to the lawyer game. Who's got the best lawyer, who's got a lawyer, and who doesn't have a lawyer, and that's not what it's supposed to be. So it's disheartening to hear that, but that was the honest answer. I mean, I could go on and on. I've got a friend that just went through a small claims experience himself, and I was there with him and watched what was going on, and he was basically treated just like dirt, basically. I'm sorry, but I think the courts with small claims cases, they need to do a better job training the judges that are handling the small claims cases. And they put out all these things that look good with here's things that can help you on the website and so forth. And it should be just common sense. A small claims court should be just common sense. I mean, you could almost throw out the rules out the window. Hey, tell me your side of the story, just like you were talking, Judge Judy does. Okay. Hey, let me know what happened. Tell me what happened here. Let's forget about this rule 267E 5-47 and all of that garbage. What happened? Okay, it's that simple. And I think not only should the small claims courts be like that, but all of the courts should be like that. Just come in and plead your case. They've made it much too complicated. It's a lawyer game. I mean, it's just, and you were talking about e-filing in the small court cases. Well, that's a mixed bag. I mean, I talk to a lot of litigants and at every level of court, and you would think that all courts would encourage electronic filing. They actually require it of lawyers. And then when it comes to a pro se, some courts allow them and some don't. And that's ridiculous. They should all be allowing electronic filing. But I can tell you for a fact that is not the case. I can tell you that as a fact. So, and also in small claims courts, it's very hard to actually prove the case in the respect that they have very limited rules, like on discovery rules, on interrogatories. When you're in state and federal court, usually they'll have some kind of a number, a cap. You can file like 25 or 30 interrogatories or whatever. But I know that my friend who just went through his small claims case, they allowed 5 questions.
Wow.
That's ridiculous.
Wow.
That's absolutely ridiculous. And another point also in small claims court, I know you asked Olivia about the percentage of the pro se's that go against lawyers and so forth. In almost all small claims courts, if not all small claims courts, they all kind of have their own rules to a certain extent. But most small claims courts require that when the pro se sues a corporation, that the corporation has to have a lawyer. In other words, an employee, the president of the corporation, whoever, cannot come in and represent. It has to be a lawyer. So here we go again. So if a pro se is filing some giant corporation, he's going against a giant battery of lawyers, even if it's in small claims court. So there's a whole lot of fixing that needs to be going on. And I'm talking about small claims here mostly because that's what your interview was with Olivia. And by the way, she did a very good job with it.
She did indeed.
So that's where I'm at with it. I mean, I'm the same. I have the same feelings about people are entitled to fairness in the small claims courts, just like they would be a person that's in small claims. That case is just as important to him as a person who's going in front of the Supreme Court. I mean, it's important. So, but they're not treated with that much respect, actually, still, in my opinion.
Your most recent experience and the subject of your book, Motion for Justice, is about the federal courts. Do you see a difference between the experience in small claims and what you experienced in federal court there?
Well, it's kind of apples and oranges because the federal courts are involved. The issues are so much more complex. You get into equal rights cases, and gender discrimination, age discrimination, race discrimination, terminations, due process, and so forth. It's just an entirely different animal. And it is a very complicated process to have to go through with in terms of there's a thing called motion for summary judgment, which generally doesn't happen in small claims cases. In fact, most small claims courts don't even allow a motion for summary judgment, but and that's actually a good thing. But so it's just it's apples and oranges actually. Just and by the way, I believe that the small claims concept could also be brought into the state and federal courts as well. Why can't you, if you have an issue with, let's just say, a police department that has been harassing you or abusing your rights in some way, shape, or form, which I certainly went through in my life, which I wrote about. Okay, but if you sue a police department, the the you should be able to represent yourself in the same manner as you would in a small claims case, with a little lax in the rules, a little less latitude, but they make it real clear to you because I went through it. They make it real clear to you. Look, we don't care if you're pro se. You're going. We have our rules here, and you're going to follow, and that's fine. But the way they've created the system, they've made the rules so complicated that there's some lawyers that didn't even know what they're doing when they go in there, to be honest about it. I mean, there's a lot of incompetence at that level as well. So it's much more complicated than it needs to be. And why can't you in a major federal case? And I just went through one in 2016. I won the case, but it's difficult to do. But most people, the people that went to my trial, and even I shouldn't say who they were, but there were court personnel actually that even asked me, afterwards, man, how did you do this? How were you able to do this, and so forth? Well, we've talked about this before in other shows that we've done, and it just takes a whole lot of preparation and homework and so forth. But they make it too difficult, and it shouldn't be.
Yeah.
People are suing, for example, police departments for wrongful arrest, abuse, brutality, or whatever. They should be able to just go in and say to the judge, "Look, judge, here's what happened." Okay, and put a couple of witnesses on. You can pretty well figure things out real quick that way. But they make it so difficult. It's mind-boggling. Our country, the judiciary, can do much better. And I'm very disappointed, to be quite honest about it.
Let
I'm
me put
sorry.
it. Let me ask you this, and this is the last question, but I think it may capture our discussion very well. There are in every state hundreds of statutes that might apply to different situations that you have to cite in your litigation. There are 6 million or so appellate cases that you might have to cite that just apply those statutes and all those rules in different ways. I mean, we've got what now 80 million or so cases in civil court every year, and obviously each of them is different. There are different fact patterns, there are different arguments, there's on and on and on. Let me ask you this then, given that, would you rather simplify the procedures, right, in court so that the average layman could operate at all levels of our courts, or would you rather get everybody a lawyer when they're in civil court so that they can apply all of those statutes and appellate courts and rules and all of that for their specific circumstances? What would
That's
be your
actually
preference?
that's an easy one for me. I go with simplifying the process and keep the lawyers out as much as possible. I mean, there's a lot of reasons, that I say that, and that could be another show. But as I said, keep it simple. Let the people come in and speak their piece. Put the evidence on, and let the judge or the jury make a decision in the case. As soon as you get lawyers involved, it's just it becomes a really, really the situation just becomes very tenuous. Lawyers, like for example, in my case, when I went through my federal trial in 2016, we had a settlement conference, and my issue was not the money. My issue was that the truth came out as to what they did. It was the principle.
Yeah.
Believe it or not, sometimes it is all about the principle. And the judge in my case, the federal judge, came out and told me, hey, they want to pay you $150,000. We were ready set for trial like in 2 weeks, and I said no. I didn't bat an eye. I said no. He said, listen, I just said 150,000. I said, I heard you the first time. And I'll leave that right there, because we had some other extended conversation with that. So, but if I would have had a lawyer, that lawyer would have been jamming that money down because he wants that money in his pocket because he gets a cut of it and so forth. So there's a lot of different reasons. And lawyers, a lot of times, they can do a lot better job in the manner and how they have this attitude about, hey, I'm the lawyer, you're not, you know what? But you're still my employee. I'm your boss, okay? And this is what I want to see happen here. But most people won't say that to the lawyers. But lawyers have this attitude. In fact, my friend is going through a case right now, and we were in the hallway talking before his hearing with a lawyer, and his lawyer was so condescending, it was unbelievable. But I just kind of, kept my mouth shut and so forth. So, the easy answer is keep it simple, and if you can, if possible, keep the lawyers out. We don't need lawyers. This country does not need lawyers. It doesn't. We can do quite well without lawyers. We don't need them. We do not need lawyers. We can survive without lawyers.
You're getting us in trouble.
Yeah, I don't know if you can be able to put that in there or not, but I mean, I'm just, I'm telling it like it is. And if any lawyer would like to come on and have a debate with me on that, I'll happy to do that.
All right, that's the challenge. We'll put that out. There you have it, Brian. Thank you so much. And I just wanted to bring you back at the end of our season here and just to capture your perspective on these many issues. I'm sharing the name of your book on our screen for our viewers. Motion for Justice. I rest my case. And you can find that at Amazon, Barnes & Noble, and fine bookstores everywhere. Brian, thank you so much for joining us. Always great to chat with you, my friend. We will speak with you again very soon.
And you as well, Sonia, Deborah. Thank you so much.
You bet.
Bye.
That's great.
Fantastic. We are way past time, but I just really am always excited to speak with Brian, and so grateful that he could help us wrap up this season of the show. Just want to remind our viewers again, tomorrow is episode number 50, after which Deborah and I will take a quick break for 3 weeks. We're going to wrap this season 1 with the 50th episode, and we will see you all tomorrow. Thanks everybody for joining us.
Are you feeling beleaguered, angry, or afraid, as if things are spinning out of control and you're powerless to stop them? It's easy to just let things slide and hope they don't get worse. But they often do get worse. The thing is, you're not powerless. Our courts belong to us, and their purpose is to give power to the powerless. Don't let your grievances pile up without redressing them. You can handle this in court, or if someone takes you to court, you can take them to school.